case briefs, and so much more. LSData's got what you're looking for.
A riveting legal dispute revolving around the rights of preferred stockholders and common stockholders in a company going through dissolution caught the attention of the Washington Supreme Court in 1951. Known as Hay v. Hay, this case hinged on interpretation of the term all accrued unpaid dividends in a preferred stock agreement and an applicable statute. The saga began when a battle for financial distribution erupted amidst the ashes of a liquidating corporation. The big question loomed. Should preferred stockholders, with their contractual guarantees, be entitled to receive accrued dividends from corporate assets before common stockholders get a share? Earlier in the trial court, the gavel had landed in favor of the preferred stockholders. They were adjudged to receive a sum equivalent to 6% per annum on their shares' par value, spanning from the issuing date right up to the liquidation date, prior to any distribution of assets reaching the common stockholders. The decision had set off a stir, with the appellant suggesting dividends should only be deemed payworthy from surplus profits, while the respondents countered, asserting that their due of accumulated unpaid dividends from assets during liquidation is guaranteed in the Articles of Incorporation. The Supreme Court stepped in and affirmed the lower court's decision, declaring the respondents, the preferred stockholders, should be first in line to receive all accrued unpaid dividends and the par value of their cumulative preferred stock during the company's liquidation, leaving the common stockholders, the appellants, to follow. What made this verdict particularly stirring was the court's explicit order that trustees are obliged to distribute dividends only from net profits, with the exception of contributory dissent or absence. Failure to comply attracts liability, as it infringingly alters the very essence of preferred stocks, providing investor security. Ultimately, the court stood by the preference intended for preferred stockholders, underscored their entitlement, and effectively shook the way common stockholders perceived their standing during a corporation's dissolution.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.